Good morning, everyone. And we are delighted to see so many of you here today for this webinar, which is the first of our 5 and 25 countdown series on the Procurement Act 2023. Some quick introductions. My name's Jenny Beresford-Jones, and I'm a Senior Legal Advisor and Public Procurement Specialist in the procurement team here at Mills and Reeve. And I'm here today with my colleague Shaylee Howard, who many of you will know already. Shaylee's a Principal Associate and Procurement Specialist, and also Darcy Sutcliffe, who is an Associate in our Commercial and Procurement team, and who I know is absolutely delighted to be doing her first 5 and 25 with us. So good to have you with us, Darcy. Before we get going, just a quick note on where we are on the procurement bill, which has been ping-ponging between the Commons and the Lords, and I think the next date scheduled for debate is the 24th of October. So probably we won't see royal assent before then, but as there's only one issue outstanding, I think it might follow very soon after. And after that, the Act will be on the statute books, and we will be on the road to it coming into force. So currently the government is saying October 2024 for that, with various learning and guidance initiatives being released along the way, as well as a whole host of secondary legislation which is needed to provide the more granular details of how the Act is going to work in practice. So do bookmark our procurement reform page, as we'll be keeping that up to date. And also do have a look at our webinars page, where we will keep a copy of all of the webinars that we've done, including this one. It's a real mine of information. You can see the recordings and the slides and all the questions and answers that were asked in each webinar, so it's really helpful. And even though we're going to have the new Procurement Act, a huge amount of this information will still be really relevant and helpful, so do take a look at that. And I think that's all I need to say by way of introduction. So I think we can make a start. And I think, Shaylee, you're going to talk to us first about pipeline notices. Thank you.
Good morning, everyone. So the first question we're going to look at is what's a pipeline notice. This is something that that is new in the procurement bill, and a theme that you will see throughout the bill and throughout the tenet of the new regime is that transparency is key, and as part of that, pipeline notice is required. So what's that? What is a pipeline notice all about? So at the planning stage, if you're a contracting authority that considers that it will spend at least £100 million in the forthcoming financial year, you must publish a pipeline notice. And that has to be published within 56 days of the start of the financial year, which starts on the 1st of April following implementation. You have to cover all potential spend in the reporting period, and the reporting period is 18 months from the start of that financial year. You don't have to publish all notices, all contracts, you'd be pleased to hear. It's just those that are valued at £2 million and above. But interestingly, it covers not only contracts that you are intending to run a competition for, it also includes directly awarded contracts as well. So that's quite an interesting change from what we have currently. In terms of what needs to be included in this pipeline notice, well, as Jenny said, there are a number of consultations that have just closed, including the drafting of some statutory legislations and secondary legislation, which sets out the detail to be contained in all the notices, including the pipeline notice. So at the moment, and it is subject to change given that these regulations are only in draft form, you have to include details of the contracting authority, as well as the unique identifier. Now, at the moment, the draft regulations talk about the unique identifier of the procurement, but query whether this is right, given that it's a pipeline notice that will cover potentially a number of procurements and contracts. So perhaps that ought to be the unique identifier for the contracting authority. This is a special code that the authority will have, and the idea is that suppliers can track the activity of that contracting authority. Procurements will also have a unique identifier as well. And again, same sort of idea to enable a supplier to track the story of the procurement. As well as the unique identifier and details of the contracting authority, you must include the contract subject matter and an estimated date of the tender notice, so when the contract advert will be published, or if you're making a direct award, when the transparency notice will be published. And we'll come on in future webinars to talk a little bit more about what those notices mean. So the Cabinet Office has said that the intent behind this obligation to publish a pipeline notice is to give suppliers the opportunity to track potential opportunities, and that's particularly beneficial for SMEs and really increasing the amount of engagement that the government gets from SMEs. The Cabinet Office is also keen to point out that the notice is an indication of authority plans, and authorities won't be held to whatever is in the notice. But I think it's inevitable that there will be more scrutiny of what's published, and certainly questions asked by suppliers if plans change, if suddenly a high value contract that was on the pipeline notice actually doesn't appear in either in a direct award or as a competition, or if indeed the value significantly change as well. So I think it's a good idea for authorities to be prepared to explain to interested parties should plans change. Just onto the next slide very quickly. So here's a diagram of what the timings look like. So assuming that the Act comes into force before the 1st of April 2025, you have the first financial year. You've got the deadline there for publishing the pipeline notice, as well as the reporting period as well, which goes on for longer. And of course, in the middle of that, you have the start of the new financial year, and you would expect another pipeline notice to be published within 56 days of that date. So that's all from me on pipeline notices. I'm going to hand over to Darcy now to look at planned procurement notices. Thanks, Darcy.
Thank you, Shirley. As Jenny mentioned, I am an associate in the commercial and procurement team here at Mills & Reeve, and this is my first 5 and 25. I'm sure it'll be the first of many. So my question is in relation to planned procurement notices, and what are they and what should we be including in the notices? The first hurdle I had is when I was writing my notes, I really wanted to call this a PPN. So I'll be interested to see how that pans out in the future with the terminology. So in comparison to the notice that Shirley was discussing, a planned procurement notice, there is no obligation to publish one. An authority may publish one. It is not mandatory. It's indicating an intention to publish a tender notice in the future. And again, this only relates to one procurement. This doesn't relate to a contracting authority's pipeline. It is designed to work a bit like a PIN, so it can be a call for competition, similar to what is available under the current regulations to subcentral authorities. It's designed to alert bidders to opportunities in the future, so they have as much time as possible to be able to prepare for upcoming procurements. There is also the possibility to reduce the tendering periods, but this is something I will come on to in a moment. So planned procurement notice is aimed at alerting bidders to be able to prepare and be aware of the forthcoming opportunities available. Similar to what Shirley mentioned, the information requirements are currently sat in draft regulations, so are subject to change. At present, the regulations do say these details must be included, so it is anticipated that a planned procurement notice may be quite detailed. Authorities may elect to include additional details, but we must be mindful when drafting these notices that there may be a risk of challenge, as the limitation begins from the date of knowledge. So it's getting the balancing act right with the amount of information you want to include in that notice without giving too much away. There is also this unique identifier that Shirley mentioned, and this will be in relation to the procurement, and we'll see this unique identifier in the different notices that are within the bill. This will allow individuals, authorities, potential suppliers to track the procurement from the very beginning all the way right through to the lifetime of the contract. This is again due to the push on transparency and to allow those to see every detail of the procurement. So if we move on to the next slide, please, Jenny. So as I mentioned before, a planned procurement notice can be used to reduce tendering periods, and this is known as a qualifying planned procurement notice. So similar to a PIN, if a planned procurement notice is published at least 40 days, but not more than 12 months prior to the date on which the tender notice is published, the tendering period can be reduced from 25 days to 10 days. A contracting authority does not have to take advantage of this. This is purely a decision the contracting authority can take, but this is the minimum period that they can use is 10 days. However, there is still an obligation in section 54 of the bill for authorities to set timescales that are proportionate to the complexity of the procurement. This is something we'll cover in future webinars. Therefore, the time-saving opportunity may not necessarily be beneficial for authorities in these circumstances, and this is a decision authorities will have to weigh up and decide to make. So, planned procurement notices can be used in a variety of circumstances, so to reduce tendering periods, alerting the market to the opportunities, and allowing potential bidders as much time as possible to prepare for those upcoming opportunities. I will now pass you over to Jenny for the third question.
Thank you, Darcy. So this is the third of a trio of notices set out in Chapter 1 of the Act, which is called Preliminary Steps. And this is the part of the bill which talks about something that we now call pre-market engagement, which is going to be called preliminary market engagement. So that's another one of those translations into slightly different language that we see peppered throughout the Act. So Section 17 says that you must publish a new kind of notice. So this is called a preliminary market engagement notice, which is very difficult to say. And you must publish one of those if you've conducted or plan to conduct preliminary market engagement. So to note really that preliminary market engagement itself is still not mandatory. So there's still a choice as whether to use it or not. However, as I think Shaylee will mention a bit later, with all the new flexibilities being brought in by the regime, it's likely that authorities will want to test their approach to make sure it's realistic. So pre-market engagement is a great way to do that. And I'm sure suppliers will be interested to understand as much as they can about how the procurement is going to be run in this new landscape where everybody is very new to how it's all going to work. But the new point is that if you do use preliminary market engagement, then you're obliged to publish one of these preliminary market engagement notices. It just says before you publish the tender notice. That's the contract notice as we currently know it, which commences the procurement. So there's no further guidance on what before might mean here. So presumably as long as your PME notice predates your tender notice, you should be okay. Section 17 does allow an authority to decide not to publish a PME notice, but in that situation it needs to explain why not in the tender notice, which presumably will have a box for those sort of details. So it's a sort of comply or explain approach. In terms of the content and form of the PME notice, as Shaylee and Darcy mentioned, you won't really find this in the Act itself because the content of all these new notices is sitting in the secondary legislation, the Draft Procurement Transparency Regulations 2020X, because we don't yet know whether it would be 23 or 24 that they become law. And these tell us that in addition to all the standard details that Darcy and Shaylee mentioned, identifying the authority and the procurement, these PME notices have some specific requirements. So, for example, you need to say when your pre-market engagement closed or will close, and if there's any deadline for suppliers to respond to the notice, so by submitting information or expressing interest, for example, that deadline has got to be in the notice as well. And you also need to use the notice to describe the preliminary market engagement process. So are you using a supplier event day, a questionnaire, or how are you conducting the process? And so from that, I think we can see that the preliminary market engagement notice can be used to sort of face both ways, as it were. So it can both advertise pre-market engagement that is happening and act as an invitation to any supplier reading the notice to take part, or it can face the other way and document some preliminary market engagement that has happened already. So I think it is still going to be possible to do preliminary market engagement without having to have a notice that invites the whole market. It doesn't have to function as an open invitation. But the difference now is that if you don't have a general invitation, you've still got to have a notice about what you have done after the event. So the market will be able to see that some preliminary market engagement has happened, even if it was a more closed group of suppliers that you were involved with. So that's the new thing. The new thing is the required degree of transparency being carried out, which is not really something that there's an equivalent of in the public contracts regulations at the moment. And in terms of how the Act conceives of preliminary market engagement, how it defines it, what the concept is, Shady is going to tell us a little bit about that.
Thanks, Jenny. So I'm now going to talk a little bit about what the bill says about preliminary market engagement. So if you're familiar with the current regime, the public contracts regulations, Regulation 40 talks about pre-market engagement and says that it can be used with a view to preparing the procurement or informing suppliers of the requirement. And there's very much a change in language under the bill. So we're looking at section 16 here. It's much broader in scope and more expansive, not necessarily exhaustive, but I think it gives a good idea of the sorts of pre-market engagement that can take place. So the clause talks about developing requirements and the approach to the procurement, and we see this with lots of complex procurements and potentially even sort of sharing draft tender documents to look at the design of a procurement, looking at the design of the procedure, the what are now going to be called conditions of participation or selection criteria in old money, and award criteria as well. So the bill does give you, sort of empowers you to use preliminary market engagement for that purpose too. Just thinking a bit more about developing the authorities' requirements and approach, I think this is a good opportunity to test the requirements with the supplier, but also consider things like social value and other considerations like incorporating the National Policy Procurement Statement. Section 13 of the bill says that authorities must have regard to the National Procurement Policy Statement, and that's set out in PPN 521. It talks about creating new jobs, tackling climate change, and improving supply diversity. So that could be a good time to test those things with your market to check that you are pitching those at the right level. Another interesting point is that the section 16 says that you can use pre-market engagement to identify contractual terms. This is really interesting because this is certainly an area that we will focus on in another forthcoming webinar. Authorities are able to set and publish key performance indicators for contracts with a value over £5 million. They've got to do that via a contract performance notice. So this is a new excludable ground for poor performance. So where you've got an unrectified breach, then an authority can terminate a contract. and also it's a discretionary ground for exclusion. Again, we'll come on to talk about that in more detail. I think the point for these purposes is that this means that there's going to be much more of a spotlight on those terms during the procurement process, and suppliers will be very much more interested in making sure that those are set correctly, given the consequences. So again, I think it's probably worth using the pre-market engagement to test those with suppliers before you identify your preferred bidder. The regulation I have to change my language and not talk about the regulations anymore and talk about the bill or the act. The bill also talks about build capacity. So it says that you can use pre-market engagement for the purpose of building capacity amongst suppliers in relation to the contract, which is an interesting new detail that hasn't to date been included in the regulations. Presumably here, you can use pre-market engagement to communicate to the market what the authority thinks it needs and what it might need in the future. And that in turn can help suppliers build their supply chain. So again, thinking about the SME agenda, potentially raises some questions around equal treatment and transparency. So if you aren't engaging with the market as a whole, and you are only going to a limited number of suppliers who have that intel about the build capacity that's required, query how an authority sort of levels that playing field as well. So something to think about when you are planning your procurements. I will pass back to Jenny now. You're on mute, Jenny. Sorry.
There we go. Thank you. Yeah, so the final question we've got is sort of leading on from what Shaylee was saying just then. So what does the Act say about prior involvement of bidders in the preliminary engagement process? And that's, I think, always a tricky area in relation to pre-market engagement. It's a question of, how far can you engage with suppliers without at the same time providing any of them with an unfair advantage when you actually come to run the procurement later? And the Act here, although it uses different language, of course, is really very similar in spirit to Regulation 41 of the Public Contracts Regulations. So the obligations are set out at section 17.3, and that essentially says that when an authority is doing its preliminary market engagement, it's got to take steps to ensure that no supplier taking part in that is put at an unfair advantage, and also that competition in relation to the contract isn't distorted. So that's, broadly speaking, very similar to what Regulation 41 says. And then it goes on to tell us that if there's no way for that unfair advantage to be avoided, then the supplier has to be excluded from further participation. And the key thing here under the Act, as well as under the current law really, is that here we're thinking about an unfair advantage and not just any old advantage per se. So an unfair advantage is different to, for example, a fair advantage that the incumbent might enjoy because it's worked with the authority for a long time. So that's a useful thing to keep in mind when you're trying to sort of navigate these tricky grey areas. So under the Act, as now, the need to exclude is only actually triggered if, following the pre-market engagement and the steps that you may have taken to try to guard against an unfair advantage, the supplier nonetheless still has that unfair advantage that can't be neutralised. An example might be, for example, where perhaps that there's been a bit of an information leak, and during the pre-market engagement process, one supplier has come to know what the authority's maximum budget is, and it's not possible to share that information with all the suppliers without actually sort of defeating the competitive process altogether. That would certainly be an issue where there's an unfair advantage, and then the authority would have to think very carefully about whether to exclude that supplier or indeed whether to sort of rewind and start again. Those sorts of issues are very rare. And I don't think I've ever seen a case where a supplier has been excluded on these grounds, and in fact can only be used as a last resort if the problem cannot be avoided. And our experience is that usually there is some way to avoid the problem. And of course, if you exclude that supplier, there is a risk of a challenge from the excluded supplier itself as well, who would be arguing that the authority had been too draconian in its approach to excluding it. So all of that is really quite similar to what the position is under the regulations at present. What is new, as we've been saying throughout the webinar, is there's much more transparency about what preliminary market engagement has gone on, and therefore competitor suppliers may be able to find out more about that. They may be able to identify which suppliers have prior involvement and possibly make allegations of unequal treatment and so on. So possibly more of a risk for challenge, but I think it would turn on a case-by-case basis. So as now in relation to pre-market engagement, we always advise to try to be able to demonstrate objectivity in who you engage with. So obviously a really easy way to do that is to use the PME notice to invite expressions of interest. So that's a really easy way to demonstrate fairness. Although it's sort of understood that you might not have the resources to engage with everybody who responds. But if you want to narrow down that field, ideally you need to have some sort of objective process to choose who makes the cut. Before you start doing your pre-market engagement, do you think really carefully about the parameters around it? And I'm thinking there about so that your colleagues conducting it are aware of the need to avoid what I think of as information drift and telling one particular supplier more information than they need to know. Being really careful about supplier commercial confidentiality and having proper sort of parameters in place to protect that. And I'm borrowing a phrase from Shaylee, which is that procurement loves an audit trail. Always have a good audit trail of how you managed and conducted your pre-market engagement process. And if you have that, that will then allow you to analyse it, to see whether there is any unfair advantage and whether you need to take any steps to remedy that. And as I said earlier, do have a look at our previous 5 and 25 webinar on pre-market engagement, as much of what we talked about there remains relevant under the new Act. And do look out for our next 5 and 25 countdown webinar. I think that's going to be Wednesday, the 29th of November at 10 o'clock. And I think we're going to be talking about routes and processes under the Act, which would be a really interesting topic. That's an area where quite a lot is changing. As I mentioned at the beginning, really appreciate it if you could fill in the feedback form, which hopefully will pop up shortly, both on how you found the session today, but also with any of your observations about how the Act is going down in your organisation, what challenges and opportunities you see. We're really interested to hear from you on that. And I think that is all from us, and I hope you have a really good day. Thank you.